case number 22, People versus Oscar Sanders. Ms. Shibley, welcome.
Good afternoon. My name is Shanta Sibley, and I'm here from Appellate Advocates on behalf of Appellant Oscar Sanders. I'd like to reserve 2 minutes for rebuttal.
Fine.
As a hospital patient being treated in an emergency room, appellant retained a reasonable expectation of privacy in the clothing that was being stored by the hospital for safekeeping on his behalf. Because appellant had a privacy interest in his clothing, the full protections of the Fourth Amendment applied to that clothing, which meant that in order for the police to search the clothing, they needed to have consent.
Is it a diminished privacy interest?
There's no
Given that
diminished
it's in a
privacy
plastic
interest.
bag outside in the open?
The plastic bag wasn't outside in the open. So what the record shows is that appellant had been gowned because he had these injuries and was being actively treated in the emergency room. The clothing had been put into a hospital bag and placed on a shelf underneath a gurney. And so there's no indication from the record that the clothing was out in the open or was somehow available to the public.
Was it near him, or was it some distance away from him, the bag?
At the time that the officer came and spoke with appellant, the bag was actually 15 feet away in a different room. But the record shows that appellant had been in that room, and so he had been in the trauma room and then was in the hallway at the particular moment when the officer actually came to talk to him.
Well, it isn't the enclosure, though. Isn't it the visibility that's the question here? And the clothing was clearly visible, right?
No, the clothing was not clearly visible. And so actually there are several.
So it wasn't in a plastic hospital bag, closed up, in a separate room from the defendant?
It was in a plastic hospital bag.
Closed up.
Sealed
Right.
hospital bag in the trauma room, yes, and that defendant was outside of.
And the plastic bag wasn't clear?
The officer testified that the plastic bag was clear, yes.
So it's visible then?
The bag itself was visible, but there's no indication that the clothing within the bag was visible
Okay.
to the
Well,
officer.
the bag is see-through?
Well, the bag is clear, but the officer did not testify that he could see anything through the bag.
Well, let me
And
ask you
so-
a different kind of question. The officer knew before seeing the bag that there were clothes, correct?
Correct.
There
The
were
officer was
clothes,
told that his
and
clothing
at
was in the
that
bag.
time formed some opinion that these clothes might have some evidentiary value. Is that correct?
The officer did not form any opinion that the clothing may have some evidentiary
So
value.
at what time did the officer think there might be some reason for me to look at these clothes?
After he took the clothing out of the bag, engaged in a warrantless search,
But
and
what
compare
inspired
the
the interest?
boxer.
But what inspired the interest in the clothes?
Excuse me?
What inspired the interest in the clothes? Why go through that if you don't think there's a purpose to it?
Merely that another detective told him that my client's possessions were in this bag. So he went basically on a fishing expedition and looked in the bag to see if he could find anything
He knew that
there.
your client had said that he had been shot.
That he had been shot in Liberty
He
Park.
was called there to investigate this shooting, correct?
Correct.
And so wouldn't it make sense that I mean, why would he go in the bag if he wasn't looking for some evidence with regard to this shooting?
Well, absolutely not, because he did not interview my client extensively. He did not see any wounds, so he didn't know where my client was shot.
Well, he said he was shot in the leg, didn't he?
No.
He just said he was shot?
No, just that he was shot. And so the officer did not know where my client had been shot. He didn't know what items of clothing were in the bag, so he didn't even know if boxer shorts would be in the bag. I mean, my client could have very well been wearing his underwear under the hospital gown. And so there was no reason for the officer to believe that anything in the bag would be incriminating.
So you're suggesting then that the officer went in the bag because he was looking to get your client on something?
I'm not imputing any motives to the officer. I'm not saying he was trying to set my client up
Would
or
it matter?
do anything.
Would it matter?
I don't think it matters at all. What matters is, well, actually, a couple things matter. One is that even though we're talking about the plain view doctrine, as an initial matter, the plain view doctrine is not preserved in this case, because that's not the theory under which the people supported the search at the suppression hearing.
That's not the theory the court ruled on, but I thought that was in their motion papers.
There was one clause in their motion paper.
You know, I wouldn't waste time on that. I don't think that's a very strong argument. I really think you should move off that argument. That's the preservation argument. Maybe, maybe not, but, you know, I would
Okay.
I would stick with your stronger arguments.
Well,
You know, what I'm wondering about is how does this case compare to People v. Cook? I think you
Yes.
should address that.
Okay.
Yeah.
People v. Cook actually gives us the same facts, but actually more damning facts for the defendant that was in Cook. So in Cook, we have a hospitalized patient. He's wounded, and there actually is a suspicion that he has committed a crime in that case, as opposed to in my case, where at the point at which the officer conducted the search, my client was considered to be a victim.
Big difference that I see is that the clothing in Cook was lying next to the hospital stretcher. And the defendant, I believe, there was lying incoherent on a stretcher. And then the materials were gone through then, and he was arrested on the basis of what they found. It was a pile of clothing.
Right.
Here, it wasn't in a separate room, and it wasn't in a clear plastic bag as it was here.
Well, the clothing in Cook was actually, if we're going to rely upon the plain view doctrine, the clothing in Cook was actually spread out on the floor and was available for the officer to see. Here, that's not the case. Here, my client's clothing was in a bag that was sealed, and the officer testified that he had to inspect the clothing, that he had to lay out the boxer
So what-
shorts
what
next
if
to the jeans.
What if the bag, the clear bag, showed, if it's possible, I don't know that it's possible, showed the underwear with bullet holes, but the officer could see through the bag that the jeans had no bullet holes?
I think that if there was testimony that the officer could develop probable cause to believe that it was evidence without touching the bag, just from looking at it across the room, so if he could see those things, I think that would be a different situation. But that's not what the record is in this case. There's no testimony, and it would have been the people's burden to elicit that testimony
What were the
at
specific,
the hearing.
I'm sorry, what was the specific ruling of the trial court? What did it base its decision on?
So the trial court said that it was unsure whether or not my client had a reasonable expectation of privacy in the clothing, but that he didn't see a Fourth Amendment violation because the bag was, quote, potentially was evidence of a crime.
Is that an appropriate grounds to forego the Fourth Amendment?
That is absolutely an inappropriate ground to forego the Fourth Amendment. There's no Fourth Amendment exception for potentially the evidence of a crime. And
Can a
here-
victim deny access to law enforcement of evidence of a crime?
Can a victim deny?
Yes.
Absolutely. And so one of the situations that this would actually affect quite often is a rape victim, right? Because if someone comes into the hospital and they're a victim of rape or, say, domestic violence, and they're wearing clothing, that clothing would also be potentially evidence of a crime, generally speaking. But we've held, and we understand as a community that that victim has a privacy interest in those things, and so those things cannot be searched without their consent or without a warrant or without some other recognized exception to the warrant requirement. And that's the same situation that we have here.
Thank you, Ms. Sibley. Mr.
Thank you.
Brannigan?
William Brannigan for the People. Good afternoon, Your Honors. May it please the Court. Your Honor, the police properly seized the clothing found in a clear bag on the hospital floor as evidence of a crime that they were investigating, in particular that the defendant had been shot.
Shouldn't they, one of the arguments that Ms. Sibley makes is that you could always ask permission. And the reason I thought about that was, let's assume for a minute that all the facts are as indicated here, but this particular defendant had marijuana in his pocket when he was shot. He was assuming he was a victim, and he didn't want the police to know that because he was going to be charged with possession of marijuana. So he doesn't want them to look at his clothes, not having nothing to do with the particular incident involved. Has he forfeited his right to protect his privacy interest in his clothes by being the victim of a shooting?
No, Your Honor. There's two things here. One is the probable cause that there was a crime that was committed, which was the shooting of the defendant, and secondly, that the evidence of the shooting was in a clear bag on the floor. So in this case, we're relying solely on plain view, not that there was consent. The
Doesn't
defendant
plain
could have...
view imply that you have the fruits of a crime or the crime res has to be in plain view, not simply, you say, well, this apartment is in plain view, I can search it, or these clothing is in plain view, I can search it. In other words, it has to be what you're looking for has to be in plain view, right?
The standard is whether it's useful as evidence of the crime.
I thought
And-
it was whether or not the instrumentalities of the crime, I thought. That
Ins-
was it. And so is clothing an instrumentality of the crime?
Well, it's instrumentality of the crime or useful as evidence of the crime, Your Honor. So
Take the example that your adversary just raised about a rape victim who's still in her clothing when the SVU police officers show up, and she has something that she doesn't want them to see. I don't know what. Maybe she's got a weapon in there. I'm not sure. And she says, no, I don't want you to take my clothing. We know that there's been a report of a rape, right? And there's suspicion that a crime has been committed and this person is a victim. So do they take the clothing or not, under your theory?
I'm pretty sure you can't seize clothes off the back of a person, Your Honor. The difference would be if let's say, and again, this would not be how a rape kit was typically done. Let's say that there was a rape kit done. Let's say she was in another room in a hospital gown, and for whatever reason they left her clothes on the floor from the rape. That might be a different situation if the officers came in investigating that. That would be a very odd situation. So the difference here is that the clothes are on the floor in plain view.
Well, but they're in a sealed bag. Doesn't that suggest that hands off? This is the private, personal property of someone?
No, Your Honor, because it's a clear bag. So
He doesn't have any choice over that, right? That's what hospitals provide. This person does not have the option to try and secrete this bag.
Well, Your
Or
Honor,
to use a different bag.
Your Honor, we don't know that from the record. There is evidence to the record that this is a clear bag, that the officer who was in the room lawfully was able to see what was inside of that bag.
All he could
What
see,
the
though, counsel, what if all he could see is what I think the record suggests is that there are clothes in the bag. He has to go inside of the bag to find out that the underwear have bullet holes, but not the jeans.
Your Honor, ultimately the clothes have to be analyzed for the ballistics evidence. But he knows the clothing, as a trained officer, he knows that the clothing is always going to be evidence of the shooting.
But isn't that then the problem? He only knows that, following off on what Judge Abdus-Salam is saying, he only knows that because he knows there's a shooting, shot in the leg, right? Supposedly, I understand the adversary disagrees, but let's just stay with this for one moment. He knows there's a shooting, he knows there's a shot in the leg. So those clothes must have holes, they must have something of value, but he really doesn't know anything about that, or the officer wouldn't know anything about that until you go through a forensic analysis of this evidence. So he learns nothing. What I'm saying is he learns nothing from the observation, right? He only thinks there's something valuable because he knows about the shooting, he knows the shooting in the leg, the clothes must have been affected in this shooting. He doesn't know anything from seeing the bag, correct? He's got to go looking for something.
Yes, Your Honor. He has to examine the clothing to know exactly what kind of ballistics evidence they'll yield, but it's the clothes themselves that are evidence in this crime. So the standard is...
Take a step back. We know the standard, all right? But take a step back. Normally, plain view is a policeman pulls you over, you got an open beer in the car, he sees the open beer there, it's in plain view, he can see it. He said, were you drinking that? Yeah, boom. It's in plain view. Here, the incriminating nature of the object usually has to be apparent, like drugs or alcohol or a gun, something that's readily apparent. You see it when you come in. So the question, that's why we're asking these questions, obviously, because I'm trying to see how the incriminating nature of the object here, the instrumentality of the crime, the clothes, is apparent when it's closed up and inside a bag.
Your Honor, because in every shooting case, the clothing is evidence of the crime. They're always going to have some kind of forensic, some kind of bullet holes. They'll have blood.
What's your rule then, that in any shooting case, all clothing is subject to police confiscation and inspection?
Your Honor, when the clothing is out in the open, when there's other...
Wearing it.
No, Your Honor...
I just have trouble...
You've relinquished your... The reasonably objective officer does not see any privacy interest in a bag of clothes on the floor that he can see. If your clothes are on your back, that doesn't mean he can see your...
Maybe he's wrong, is my point. I was thinking, too, let's suppose you're a hit-and-run victim, and you're in the hospital. The police come to investigate. You're saying that because you're a victim of a crime, you are forfeiting your right to your privacy with respect to that clothing. And if you have a gun, if you have drugs, if you have anything like that, that's too bad, because they have an absolute right to your clothing and all of the fruits of that investigation. That doesn't make sense to me. It sounds like it's violating the Fourth Amendment.
No, Your Honor. Again, you've laid out a few different scenarios there, hit and run in these different scenarios. Now, first of all, just as policy in hospitals, and the court, if it wants to, can look at, there was actually 2 cases in the appellate division from our office at the same time. One was Salvoden. I can't remember the name of the second case.
Are they in your brief?
And those are not in the briefs, Your Honor.
Why don't you send them up then after argument?
Okay. In those 2 other cases, in one case, the appellate division found that the search was unlawful because the property was held in safekeeping by the hospital. In the second case, it was being held by the nurses in an opaque bag that the officers asked for. So those are 2 different situations. Here, the officers arrive at the hospital to investigate the shooting of this defendant. They see clothes that the officer knows by his training to be evidence of that crime.
Was
The
there
officer
blood on the clothing? What other than that they were in a clear plastic bag and someone said they belonged to the defendant, you're saying that the officer was drawn to that. What if the defendant had been shot in the hand, not in some portion of his clothing, and no bullet holes would have appeared in any part of his clothing, that he had been shot through the hand and the bullet came through and through? Would the clothing be important then?
Your Honor, again, it could be that there are situations where the clothing would turn out not to yield evidence, but the clothing is always useful as evidence in this type of case, and that's the standard.
That's a broad rule, don't you think?
It's not a broad rule, Your Honor.
Why wouldn't you ask for permission? Why wouldn't you ask?
Your Honor, this is a very atypical case. It is not the normal thing for the officer to come in and find the clothing as it was found here.
Why wouldn't you ask? I mean, couldn't you just said, we'd like to look at your clothes?
He could have said that.
And if the guy said, no, I don't want you to look at my clothes, could he then gotten a warrant?
Your Honor, yes. The answer to both questions is yes. But here we have plain view. So it was not.
Let me go back to you on plain view. Judge Fahey said this. Plain view is of the contraband, of the weapon, of the res that formed the basis of the crime. It's not, well, I was in the apartment and it was clear that in plain view was tinfoil, and I know that tinfoil can be used in packaging drugs, therefore, we had a right to search.
Yes, Your Honor, that would be plain view. If that was evidence, if you're talking about, if the tinfoil, if the trained officer can say that.
It's Reynolds wrap. It's in a roll.
Your Honor, in a drug case, under the circumstances, the tinfoil found in plain view could be useful as evidence of that crime. So
what is the case, you keep intoning useful as evidence, what is the case that supports that proposition?
Your Honor, it's one of the Supreme Court cases. It's cited in our brief.
I thought it was Horton that was where I found the language from, but I could be wrong.
Okay, so if the hospital used opaque bags and the officer knows the clothes are in there, your position is that's not plain view, the officer's going to have to ask, and if denied access, would then have to try and get a warrant. Am I correct in understanding your argument?
That's correct, Your Honor.
Okay, so he has the victim, the defendant here, has no choice in whether or not a plastic bag or an opaque bag is used. As a victim has no choice about how to ensure that the privacy of these clothes are maintained, but the bag is sealed. Why isn't that enough to make clear that the plain view doesn't apply in this kind of a case?
Your Honor, because we have to look at the reasonably objective circumstances. We have to understand that the officer is coming in, he's dealing with this situation in a very rapid way.
I understand, but we're also dealing with we're also dealing with the interests of the defendant, the privacy interest, and there's also a property interest in these clothes. And in part, the plain view doctrine also exists because if you're the defendant and you've got things out in the open, you have diminished expectations of privacy. But in this case, he can't make any choice about that bag. That's the hospital's bag. And obviously, the hospital has taken off his clothes to give him services. He's got some diminished expectation of privacy because he's got to agree to the service, the medical services. But does that mean then when they seal the bag that somehow it's free for officers to just go in and rip it open and take everything out?
Your Honor, if they can see what's inside here, he could see what was inside.
But they
It's the
learn
same-
no more by seeing than they do by knowing that he's been shot, because the only interest in the clothes is because you know he's been shot. There's no observation, there's no information gained by the observation of the plain view, is what I'm saying. And certainly that's counterbalanced by the sealing of the bag that shows that it's supposed to be a private bag. Everyone can't go in there, right? If someone walked by and went in that bag and took something, he's got a claim against them, does he not?
Yes, Your Honor.
Okay, so it's not like he's got sort of everything out in the open in that way.
But again, even if it wasn't in the bag, the same would apply. Nobody could simply come in there and take the clothes out of the hospital. It would be the same as if his clothes had simply been left on the floor. If the officer had came in 5 minutes before, it's possible.
If it's in the clear bag but in a closet in a hospital room, could the cop have opened the closet door and gone in?
No,
It's
because
in a clear bag.
No, Your Honor, because it wouldn't satisfy the first two prongs of
Because he had to
plain
open the
view.
door.
Yes.
Yeah.
Well, in Cook Counsel, the clothes were on the floor, and we said that was not good enough.
In Cook, the people are making completely different arguments. In that case, the people are arguing that there was probable cause to arrest the defendant, and based upon that arrest, the clothing was properly seized. There was never an idea that, for instance, that there was a crime that had occurred. There was no knowledge of that. So there was no support in the record for the people's argument in that case. Plain view was never argued in that case.
Thank you, Mr. Brannigan. Ms. Sibley, you have 2 minutes.
Thank you, Your Honor.
I just want to follow on from the last line of questioning, which is that a patient's Fourth Amendment protections shouldn't depend on the vagaries of any given hospital policy. And so the Fourth Amendment shouldn't depend if you go to Jamaica Hospital by ambulance, you have full Fourth Amendment protections because they put a bag in a closet or they have an opaque bag. But if you're brought to Long Island Jewish, all of a sudden you don't have Fourth Amendment protections. That's not how the Fourth Amendment operates.
That may actually be the case. Because here we're not talking, in one instance, we're talking about a search where something's in a room and whether or not you had the right to search it. If it's closed, in a closed space in a room, you may have an expectation of privacy where you don't. In an open trauma room where clothing is laying on the floor or inside of a bag that's visible, that's a seizure, that's not a search. So it's a different situation. You don't have the same expectation.
Well, according to
I
Arizona...
hate to drag you down this road, but we haven't even talked about the Sandoval issue at all.
Yes. Yes.
To either of you, so, all right.
Can I just answer that?
Go ahead.
Because according to Arizona v. Hicks, they're both searches. According to Arizona v. Hicks, once the officer has to move the clothing, once he's not merely observing it, then that's a search as well under the Fourth Amendment. And so if we find that the patient retains his privacy interest in his clothing, and this is not a question of does the cop believe that he has a privacy interest? Under the Fourth Amendment, the privacy interest is whether or not the person evidences a subjective desire for privacy and whether or not society believes that that's reasonable. And so is there a reasonable expectation of privacy, not whether or not the officer believes that the item is private.
Counsel, I'm also interested in your Sandoval.
Yes.
But I also would like you to address what your adversary said about the difference between this and Cook.
There is no meaningful difference between this case and Cook. My adversary has said that Cook is a search incident to arrest case. There's nothing in the decision that tells us that. What this court held in Cook was that even though the clothing was on the floor, even though the police were aware that a crime had been committed, and even though that person had been shot, that because there was no warrant, no consent, and no exception to the warrant requirement, that it was a violation of his Fourth Amendment rights. And that is the holding in Cook.
Would you take a couple minutes? I know your red light's on, but
Sure.
there have been a couple of questions about Sandoval.
Absolutely.
And the appellate division seemed to think that, I'll say, no harm, no foul.
That is what
What's
they
your
seem to
position?
think. Well, the standard, if this court finds that my client was not at a Sandoval hearing, is that it's only harmless if the Sandoval ruling was wholly favorable to him. And that is the standard, wholly favorable, so favorable in every way.
What about
Here,
if it was superfluous?
Well, those two concepts are linked, right? Because Favor and Monclavo say that my client's presence would only be considered superfluous if the decision was wholly favorable to him, right? And so in that case, there's nothing conceivable that he could have said that would have gotten him a better result because he got the best result
Well, so we can't
imaginable.
look at, what could, here, the inquiry that was allowed was limited to the fact that he had these convictions, but none of the details about them. So what is it that the defendant, as opposed to his counsel, could have offered in that discussion that would have made a difference there?
Right. Well, Monclavo and Faber say that we can't speculate as to what exactly he could have offered, or
So you're equating superfluous with wholly favorable or unfavorable?
well, that is what the case law, I believe, tells us, is that his presence can only be considered superfluous if the ruling was wholly favorable. Here, the court's position was that because the ruling was highly favorable, that somehow that's enough. But under this court's case law, that's not enough. It has to be wholly favorable. And we can think of a lot of other rulings that would have been more favorable to him, especially because in this case, his defense was merely that he was a victim of a crime. And so bringing up the fact that he had a criminal history makes it seem less likely that he's an innocent victim of a crime, perhaps, to a jury, and so would have made him less likely to testify.
We'll take a look at it. Thank you.
All right, thank you.
Mr. Brannigan, since we went into overtime, I think we owe you a minute or two if you want to address the Sandoval.
Thank you, Your Honors. Just briefly, what the Court of Appeals has held is that the defendants, or back when it made these rulings, was that the defendant's presence was useful basically so he could address the particular facts, the particular underlying facts. He could address the DCGIS reports, or if there was no conviction, that he could address the particulars of prior bad acts. Here, he would have been superfluous because there was.
So you don't agree that superfluous is equated with wholly favorable or unfavorable?
I would actually.
Well, the most favorable outcome here would have been they couldn't inquire at all, right?
That's correct, Your Honor.
Okay, so this wasn't wholly favorable. It was a pretty good result, but it wasn't wholly favorable.
Your Honor, it should be two different concepts. First of all, these decisions were based on the defendant's utility at the proceedings. So if it's determined that the defendant would have no utility at the proceeding, nothing to contribute, then the attorney could make the decision, or rather in this case, basically consent, make the agreement on his own.
Well, you'd be conceding that he's not there. One of the things that struck me was we're not exactly sure, and I'm wondering if maybe were we to decide that Sandoval was important here, that we ought to send it back for a reconstruction hearing. Does that make any sense to you?
Your Honor, we're not. First of all, we're not conceding that the defendant was not present. The record is.
It's their burden to show that he wasn't present.
Yes, Your Honor. By substantial evidence, it's their burden to show that he wasn't present.
So the only proof that's offered is the phrase "one coming out" that's made by the deputy during the beginning of the afternoon session in court.
That's correct, Your Honor.
Okay. All right. So, all right.
Thank you, Mr. Brannigan.
All right. Thank you, Your Honors.